I think I'm the only one that the microphone fits. There's a lot of people here I know tonight, and I'm Leslie McKinney. And those of you who are my friends are probably shocked at the fact that I'm not in jeans and tennis shoes right now. But I want to explain the difference. By day, I'm Leslie McKinney of McKinney, Wilkes & Meade. But by night, I'm the blue-collar, FFL holder, NRA instructor, gun shop owner. So tonight, I'm going to talk about the mixture of those worlds. I'm going to talk a little bit about the law of self-defense and what I call the myth of stand your ground. There's been a lot of public outrage lately, and it's been fed by the media about how horrific and brutal Florida stand your ground law is. We've been bombarded by lay people, non-Florida lawyers, everyone trying to convince us what the Florida law is and how terrible it is. In reality, the law that applies is Chapter 776 of the Florida statutes. This is it right here. It's entitled The Justifiable Use of Force. Stand your ground is merely one small paragraph out of 11 sections in that law. It reads, a person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has a right to be has no duty to retreat and has the right to stand his or her ground, meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. There's 4 basic principles summarizing stand your ground and the justifiable use of force. And it shows that it isn't the terrible boogeyman that the media and the public would have you believe. The first principle is innocence. You aren't breaking the law, and you aren't the one who initiates, sustains, or escalates the conflict. Now, the important part to remember about that is that you aren't the aggressor. But aggression is not a static moment in time. Aggression is fluid. For example, if I walked up to you and slapped you, I'm the aggressor. I turn around, walk away, you're upset at that, you shoot me, guess what? I'm not the aggressor anymore. Aggression can change from split second to split second. The second principle is imminence. The threat has to be right now, and the person has to have the ability to carry it out right now. Virtually all states have some sort of self-defense law on the books. The only difference between stand-your-ground states and non-stand-your-ground states is the requirement to retreat when one has the possible ability to do so. So the question becomes, when it comes down to that life or death split second, do you want a jury who wasn't in that situation and probably has never been faced with such peril to decide if there was something more you could have done at the time? If the answer to that question for you is yes, I suggest at this very moment you leave here, take your entire 401k and put it into Powerball tickets. Obviously, the time in this forum doesn't allow for a detailed examination of the nuts and bolts of Chapter 776, but I strongly encourage you to read it and, more importantly, know it. We can discuss questions later, shortly after we have our question and answer period. But when Chapter 776 came into its current form in 2005, it essentially became an immunity statute. Before 2005, self-defense was an affirmative defense. That meant that, God forbid you used your firearm, your defense in court was to say, yes, I did it, but I had a really good reason. The burden was on you to show that you acted lawfully. Now, the use of force in accordance with the statute provides for immunity from both civil and criminal action. If you are arrested, and you probably will be, and charged, maybe, maybe not, the state must show by a preponderance of the evidence that your use of force was unlawful. The burden is shifted to the state. If the evidence shows that it's more likely than not that the use of force was lawful, immunity attaches. And this immunity argument can be brought at any time before the court. And remember, regardless of what the news media tells you, it's an immunity hearing. It's not a stand your ground hearing. After you read and know Chapter 776, which it's available online, understand how it expanded the Castle Doctrine. There is no duty to retreat before resorting to deadly force reasonably necessary for self-defense from your home or workplace, any type of vehicle, or your place of temporary lodging. Additionally, invited guests into your castle have the same right of self-defense as you do. 2 new presumptions were included. The first presumption says, a defender in his home, place of temporary lodging, guest of another, or in a vehicle, has a reasonable fear of imminent death and great bodily harm when an intruder is in the process of entering unlawfully or forcibly enters. Think about that for a second. When they are trying to get in unlawfully or forcefully, you are allowed to presume that there's a reasonable fear of imminent death, great bodily harm. The second presumption is the intruder intends to commit an unlawful act of force or violence when he's doing that. The law remains that the actual intent of the intruder is irrelevant. However, these presumptions do not apply and do not protect you in a couple situations. When the intruder has a right to be in the home, car, place of lodging, etc., unless he's under a domestic violence injunction or no contact order, is seeking to remove a person lawfully under his care, such as a parent going to retrieve a child, or is a law enforcement officer acting lawfully, and you know he's a law enforcement officer. Now here's the gist of Florida self-defense law. If you've heard nothing else I've said, and I boil it down to 15 seconds. You may resort to force up to and including deadly force if you are in a place you have a legal right to be. You have a reasonable, imminent fear of death, great bodily harm, or forcible felony. And you're not the aggressor or breaking the law. But it's also important to remember while we're here talking about the Second Amendment that the use of force is not restricted to deadly force. There is non-deadly force. Deadly force is never appropriate to merely protect property. And remember that the statute states that deadly force may be used in instances of forcible felonies, not all felonies. As I stated earlier, you may meet force with force, but not intentionally escalate the force. It's unrealistic to think that the vast majority of us in here tonight don't have a concealed weapons permit and are currently carrying. But how many of you have thought about personal defense in situations where deadly force is inappropriate? I urge you to consider alternatives to your firearm, perhaps pepper spray or some solely defensive item for times where you're endangered, but not to the extent requiring the use of deadly force. And this is an appropriate time to briefly discuss Chapter 790 of the Florida Statute, which deals with the carrying of weapons. The first question is, what is a deadly weapon? And I submit to you that besides the obvious, it depends on how it's used. For example, I might have a baseball bat in the back of my car right now because I'm heading to a softball game. However, if I use that same benign sporting good to swing for the fences against your head, that has now become a deadly weapon. Items specifically excluded in Chapter 790 from the definition of weapon are excluded because they're considered defensive in nature, such as pepper and chemical sprays in amounts of 2 ounces or less, or electronic weapons that don't fire projectiles, such as stun guns versus tasers. Common pocket knives are excluded from the definition of weapons, but I believe that's based more on their utilitarian function rather than their defensive-only characteristics. They are still, trust me, considered deadly when used as weapons. But interestingly, Chapter 790 itself does not directly define the term common pocket knife. Among the provisions of 790 regarding obtaining a concealed weapons permit, one must show the ability to safely handle and discharge a firearm. And I maintain that if that is the full extent of your training, you are woefully underprepared. I urge you to consider the following. When couples are carrying, have you each considered your roles and actions in the event you may need to draw your firearm? Your positioning? Who covers whom? How to avoid each other's crossfire? What is your home defense plan? Where are you and your firearm in relation to the rest of your family? Do your children and other family members know the plan to avoid the danger of the confrontation? If you think about the layout of your home, should an intruder enter in the middle of the night, are as likely points of entry in between where you and your protection are and your children in other bedrooms? If you do need to fire, where is that bullet going to go? And we all know the maxim of not pointing your firearm at anything you do not intend to shoot. But how many of you have tactical lights attached to your defensive firearm? Is it really wise to use your gun as a flashlight and risk a startle response? Lastly, and this has been said before, but it can't be stressed enough, disregard the reports you hear of tragedies being avoided merely because someone pulled out their defensive firearm. Stick to the rule that you do not draw your weapon unless you intend to fire. Because just because you intend to fire when you draw your firearm, the gun's not going to fire until your booger hook presses the boom button. You can always not fire as the situation dictates. Showing your firearm is never a defensive plan. You could be the one escalating the event at that point. And there are instances where merely brandishing the firearm is considered deadly force, which becomes a major issue for you if deadly force was not warranted to begin with. Firing your weapon is always deadly force. I guess that goes without saying. However, there are no warning shots. If you fire your weapon, it must be in response to the threat as we've discussed in Chapter 776. To fire at anything but that threat, by definition, is firing at something that isn't a threat, as talked about in 776. And you never shoot to kill. You are not shooting to kill. You shoot, if necessary, merely to stop the threat. So that's my white collar and blue collar little plugs right there. So enough of my soapbox. I believe we're going to have a question and answer period afterwards. And I have a feeling you guys are going to be coming up with a lot of great questions. Thank you.